Good morning, sir.
Good morning. Sit down.
I heard, sir, you are out of station. I will be waiting for you.
Tell me.
Actually, my brother was arrested by police. I don't know any legal aspects, so I want help from you, sir.
You know, I think this is the basic problem with a lot of people in India these days. They don't know the simple code of criminal procedure. You know what? Let's talk about the code of criminal procedure. So, first things first. What is the code of criminal procedure? Now, listen to this very carefully. The procedure adopted by the police, the courts, the lawyers, and the administration in any criminal proceeding is called the Code of Criminal Procedure. Everything related to criminal law comes under the Code of Criminal Procedure, like
FIR.
the first information report, or in simple words, the FIR. The FIR is a first step towards any investigation in any event of crime.
Sir, please write an FIR, sir.
What happened?
Sir, somebody stole rupees 2100 from my bag, sir.
Okay. Tell me the whole incident.
The complaint lodged with the police by the victim of an offense or by someone on his behalf or her behalf or any other person who has witnessed the incident is called an FIR or the first information report. The FIR is registered under section 154 of the Code of Criminal Procedure 1973. Now, the same section makes it a legal duty of the citizen to inform about any crime committed in their locality to the nearest police station. The police can also suo motu lodge an FIR in cognizable cases. Suo motu means on their own. Now, some facts about FIR registration. Once a police officer has written it down, he or she will read it back to you so that you would know all the details have been covered. Always remember to sign the FIR if you are satisfied with it.
But what if police denies to register an FIR?
No, a police officer cannot deny the registration of an FIR. If he does so, you have various options. Make a complaint to a higher ranking officer like SP or DIG or IG, or send a written complaint to the SP by registered post. Any communication in writing or video will become an FIR. You can personally register a written complaint at your nearest judicial magistrate or send it to the State Human Rights Commission or the National Human Rights Commission.
But what proof would I have that they have registered the FIR?
Once the FIR has been signed, registered and recorded, the police must give the individual a copy of the FIR.
No. A copy of FIR is free of course.
Wow! That means they cannot deny registering the FIR. Anybody can register the FIR and they will ensure that I have understood the FIR. I can ask anyone to read it for me and they will give me a free copy of the FIR.
Yes.
But my problem is something else totally. My brother was arrested and I don't even know why they have arrested him. And I can't do anything if I don't know.
Let me tell you something about arrest. Normally, they will come with a warrant, which is like a notice which tells the person the reason of his arrest. Only in crimes against the human body can an arrest be made without a warrant. Nobody can arrest you or anybody else without giving the reason.
But they did not tell me anything.
Let's ask some police officer.
Not possible, sir. I'm telling you now. See, the arrested person has a right to know the grounds on which he is being arrested and also whether his offense is bailable or not.
And you know, He was in pain that day.
Then the police must have taken him to the doctor, because it's a right of every arrested person to be examined by a medical practitioner.
Can I apply for the bail?
You'll have to ask for it. Police will tell you.
Sir, while we are on it, can you please tell me what the rights of an arrested person are?
Well, let's see. They can remain silent. Any arrested person by the police or the magistrate has a right to be produced before a magistrate within 24 hours. See, we cannot detain anybody for more than 24 hours without judicial inquiry. And if the person desires, he can call up his family or his near and dear ones from the police station itself to let them know about his arrest. Yes, and they can also take legal help. If they cannot afford it, then the free legal aid is there to produce their evidence in support of their innocence.
Thank you, sir.
You need to understand bail first. See, the permission in allowing an accused person to be released from jail or from police custody with compliance to certain conditions is called bail.
So my brother can apply for bail?
Well, in order to get bail, the accused will have to give an undertaking, assuring his or her appearance whenever required by the police or the court.
So he will be released?
Well, he can be released temporarily.
But it will be granted to him.
Well, it depends on the grievousness of the offense committed, because the courts take that into account as well.
Oh, but why? I mean, why do court denies bail?
See, when the courts grant bail, it is with some restrictions, like residing at a location or at a particular address, or restrictions on traveling, or reporting to the police at specified times, contacting the alleged victim or the eyewitnesses. Also, the courts may deny bail to stop the accused from tampering with evidence. Anyway, the offences for which the accused can get bail from police stations is called bailable offence. And as for the non-bailable offences, he can always approach the courts for bail.
Okay, sir, but what should I do now?
Well, first of all, find out if the offence for which your brother is accused of is bailable or non-bailable. And if it is bailable, you can submit a bail application to the court through a lawyer. So, now you understand the Code of Criminal Procedure about FIR, about arrest, about bail.
Yes, I have.
And I believe you have also understood the Code of Criminal Procedure. And if you want to know more about it, please contact the nearest CSC center. So, I will see you later then, okay? And you too.
Okay.
Bye-bye.